You certainly don't want to be the only one sort of not doing the basic things that you need to do.
Having that documented will help you in the long run because eventually you will be subject to one of these privacy laws.
Startup founders today need to comply with a variety of privacy regulations. Even if you're a non-tech startup, you're probably still going to have a website, and that website will be subject to GDPR regulations in Europe, CCPA regulations in California, and U.S. federal COPPA law. It can be a bewildering set of regulations for startup founders to navigate. Joining me today to discuss making this a little bit easier are two expert attorneys from Foley and Lardner, Stephanie Webb and Steve Millendorf. I'm Bret Waters. I've been in Silicon Valley my entire life, immersed in the world of entrepreneurship, innovation, and venture capital. I run a startup accelerator program named Fourthly. This is the Fourthly Podcast. Joining me today to discuss this stuff are two experts in the field. First of all, Stephanie. Hey, Stephanie.
Hi, Brett.
Give us the brief background on yourself.
Oh, sure. I am in-house counsel for Wasabi Technologies, a hot cloud storage company doing it, quicker and faster and cheaper than the competitors out there. I'm a generalist attorney. I'm the only in-house attorney right now for Wasabi. So my work ranges from contract negotiations on the customer and vendor side, lots of privacy work, HR work, sort of runs the gamut. And
Wasabi is an actual unicorn, correct?
You got it.
Valuation of over $1 billion, baby.
Yes, very exciting.
Also joining us is Steve. Hey, Steve.
Hey, how's it going?
Good. Give us the background on yourself.
Yeah, so I'm Steve Millendorf. I'm a partner at Foley and Lardner. Most of my practice is privacy and cybersecurity. Counts for about 2/3, maybe a little bit more of that. The rest of it is technology transactions, which of course there's an overlap between the two because there's hardly a technology transaction these days that doesn't involve some form of data. I'm a reformed engineer. That's the way I like to put it. I was an engineer for 24 years prior to transitioning into law, mostly actually in the privacy and cybersecurity architecture space. My last gig prior to starting at Foley, I was the hardware security lead at Qualcomm for 5 out of the 7 years that I was there, and then moved into what they call government technology. So basically a government contractor helping various entities in the U.S. government to secure mobile communications.
So you're a lawyer who can actually talk geek talk.
I can, and I think part of my practice, which I think kind of sets me apart a little bit, is being able to talk to the engineers and interface with the general counsel and kind of really understand, what's going on and help direct some of the technology if I need to comply with various laws.
Right. That's great. So Stephanie and Steve, I remember the good old days of the internet where you could just post anything you want. You could grab anybody's email address you wanted. You could spam them all day long. You could collect their personal data. It's a little different now. There's a whole host of laws we have to comply with. And every website I go to now, I got to click that damn accept cookies thing. I'm so tired of that thing. So can you guys make that go away?
No. So it's interesting with that one. The requirement comes from GDPR. And it actually comes from a little bit of an offshoot of GDPR, which is the Privacy Directive.
Hey, Steve, maybe give the brief explanation of GDPR.
Yeah, so GDPR is a European privacy law. Unlike a lot of the laws, which you kind of alluded to a little earlier in the U.S., where we've got these kind of sectoral laws where it's a very specific sector of the economy or a very specific purpose. It's broad-based, right? It's all about any type of personal information, no matter what the subject is. One of the requirements in there is the idea that you only use the information for the purposes for the limited purposes that you need it for. And there's a corollary law, which is the old Privacy Directive. It's actually become a regulation in the UK called the PACR. That if you put any sort of software tracking information, anything like that on somebody's device, you have to get explicit consent. And that's where the cookie consent pop-up comes from. Now, you only have to do it once, but we have a lot of U.S. companies who are subject to GDPR for one reason or another. or we've recently seen companies who've gotten claims against them for GDPR, even though they're not subject to it. And so that's why we're seeing a lot of these cookie consent managers pop up, even for what is typically a U.S. website. It also has a little bit of overlap in the U.S., particularly under California's CCPA and what will soon be CPRA. There's a concept of selling your personal information, and selling is defined really broadly, and which would include analytics and advertising cookies, which of course a lot of websites use. And the idea is if somebody actively says, yes, you can do it, which would mean actively saying, yes, you can put cookies on my machine, that may not be a sale. But even if it is considered a sale, well, how do you opt out of selling the information, which would be a requirement under CPRA? Well, if the only way that you're selling it is through cookies, then the only way that you can opt out is through stopping the cookies, which is the cookie consent manager again.
So, Steve, you mentioned GDPR, which is a European thing.
Correct.
And this, of course, is part of the complication with all these things is that there's all these different geographies and jurisdictions around the world. And so which ones do you have to comply with, which ones you don't? So if I'm a company in the US, I assume that my website may well have visitors from Europe.
Right.
So does that mean that I have to be GDPR compliant, even though I'm a company here in California?
Absolutely not. It's not a requirement, which is a good thing. So the requirements under GDPR to be within the scope of GDPR is you either have an establishment in the European Union. And by the way, every time I say European Union, this now applies to UK because Brexit. You've got to duplicate everything.
I heard about that.
So having an establishment in Europe, obviously you're there, but if you're a US startup, you don't have that. Offering your goods and services to people in the European Union. And that sounds really broad, but there's some guidance that would suggest that you have to actually be intending to have people in the European Union access your website. So if you're just a US company, I would like to use the example of a taco shop in Kansas. Sure, somebody from Europe can go and access that website. There's no restrictions, but they're really not expecting somebody in Europe to go and access the website. So that would take you out of having to be compliant with GDPR.
Let me just say, Steve, that I love taco shop metaphors. You're talking my language now.
I went Southern California. Every corner.
So Stephanie, you're in-house counsel for a cloud service platform, which means you've got a whole kind of chain of compliance issue thing going on. Meaning, you have some direct clients, and the company has some direct customers, and so you got to make sure that you are compliant with regard to them. Also, sometimes your customers have customers who are on technology services that your company is providing. And sometimes you are integrating third-party software into your platform, and you need to make sure that it's compliant so that you're compliant, so that your customers are compliant. This sounds like a lawyer make-work scheme here.
Sure. Well, like I said, it's a big part of my job because there's just so much out there. I think I read the other day that there's 107 countries have passed privacy and security related laws. It's just a full-time job to try to keep up with the daily changes. And then, like you said, we, as in-house counsel, I'm looking at different things. So I'm looking at, data that Wasabi is collecting. So data that we hold about our employees or data that we collect, from visitors on our website. And then there's separate data that we hold for our customers and the supply chain issues there. What vendors do we use? What third-party platforms do we integrate with? So all of those things. So there's just lots of considerations out there, lots of different laws to try to keep up with, and they're keeping us busy.
So to both of you, so if I'm a startup founder today and, I'm just, we've got the early stuff going, meaning we've got a website and an email list and we're building the product. What advice would you give me as a new startup founder in terms of making sure that I'm paying attention to all this stuff?
So I think there's sort of two two buckets of advice that I would give. And the first is to really spend the time to understand the product or the service that you're offering. And that means, working with the engineers, working with the product management team, working with the customer support team to figure out how data is being handled. What data are you collecting? Where is it going? How is it data of value? And if not, do you not need to be collecting it? It's just going to give you more headaches than it's worth. Who has access to it? And then second, once you have a really good understanding of that, is when you're building your systems from the beginning, is to, I would say, focus on transparency and minimization. So minimize the data that you're collecting if you can. Don't minimize who has access to it. If you're holding data and you have 200 employees, there's probably very little reason that all 200 employees need access to, HR data or customer data. Maybe it's just limited to the HR team or the customer support team. So figure out ways to minimize those interactions, both in how you're collecting and holding the data and then who has access to it. And then the second part is just be transparent. Be transparent with your employees, be transparent with your customers about the data that you are collecting and what you're doing with it. Like Steve said earlier, kind of, use it for the reasons that you're disclosing.
Right. Steve?
And I would say, from day one, kind of consider your security posture and kind of what your security protocols are going to be. Not just for the privacy space, but for your intellectual property, right? As a startup, even before you've collected anybody's information except maybe employees, you're going to be developing a product, and presumably you're going to have some competitive advantage, or you want to, and making sure that that is not subject to various forms of espionage that we see in the industry right now, whether it's nation state, whether it's somebody else, making sure that you've got that secured. And then once the product actually launches, same thing, right? Is the worst situation that you want to be in is a startup, you're still growing, and your product is down because you've been victim to a ransomware attack or some other type of a situation.
Right.
So I think that would be the starting point. And of course, the privacy-related security all leverages off of that too, right? If you start having the firewalls and everything to protect your IP, you're going to have those same firewalls, or at least similar firewalls, to protect your personal information. And then to echo a little bit what Stephanie said is, knowing what data you're collecting and why you're collecting it and not collecting stuff that you don't need, and where all it's going, starting that from day one and having that documented will help you in the long run, because eventually you will be subject to one of these privacy laws. GDPR doesn't have any threshold other than the ones that I mentioned on whether or not you've got an establishment or you're offering your services or monitoring people in Europe. California CPRA does. There's a financial threshold of $25 million, which hopefully every startup makes it that far and has that. Some of the other state laws that we've seen are more volume thresholds, 100,000 people in some way, shape, or form. But understanding where your personal information is, when you have to start applying those data subject rights of deleting the information, well, how can you delete it if you don't know where it is and what you got?
Right.
Having access to it, correcting it, all of those data subject rights are going to stem from knowing that up front from day one, instead of having to try to back annotate it in later, and putting those engineering efforts in place early, even if you don't activate them, but having the ability to delete the information or access the information, or whatever the right is. Planning for that up front will go a long way, instead of having to figure it out of like, oh crap, now we're subject to GDPR.
Right.
Now what?
Yeah.
And Bret, just one other thing. I would say, think about who your target customer is, both kind of in geography and just in terms of the size of the kind of customer that you're going to go after. Like Steve mentioned, if you're going after only US customers, you're, in one state and you're sort of not planning on expanding beyond that, that's going to require a different sort of privacy and security program as a whole than if you're planning to go hire a bunch of salespeople in Europe and move into other jurisdictions. And then same for the kinds of companies that you're going to go after if you're a B2B company. I think we all know that sort of enterprise level customers are require just a whole different set of resources. And they're going to really drive a lot of these decisions that you're making early on. Enterprise level customers and customers subject to the GDPR are going to insist on things like ISO certifications, SOC 2 certifications, the ability to answer a 1,500 question RFP about your security and privacy practices. And if you're kind of not set up to, to handle those sort of requests and those sort of negotiations, it's really, you're not going to be successful in sort of landing those kind of customers. And so giving that thought ahead of time and sort of knowing what you're stepping into, I think is important.
Yeah, I think that's a good point is, I talked about, when you're subject to GDPR or CPRA or any of those, but there's also the infection aspect of it, as I like to term it, where your customers are subject to it. And because they're subject to it, they can't just pass the buck and say, okay, well, we don't have to do anything because we hired a vendor to do it. They're going to pass those obligations down to you, and making sure that you can handle it by knowing what your customer base is or potentially will be in maybe the next year or so, whatever it comes out to be, can go a long way when you're starting the company.
And Steve, you mentioned the ability to delete customer data for a customer to delete their own data. So I know an entrepreneur who recently had their app rejected by the Apple App Store because they had functionality for a customer to close their account, but they didn't have functionality for a customer to also delete all of their data.
Mm-hmm. And there's a requirement from the Apple Store. Particularly, it's not necessarily a legal requirement, but Apple has imposed that as a requirement that you should be able to close the account through the app and have the information that's associated with it deleted. But then, again, we do get into CPRA and all those other ones where upon request, however that request necessarily comes in, you may have an obligation to delete it with a lot of exceptions. So you're allowed to anonymize it. Deletion doesn't necessarily mean delete and wipe out the record.
Yeah.
But obviously, if you have to keep it for a legal hold or some other obligation, you're allowed to do that. Of course, you have to tell the customer why you're not following the request. All of these data subject rights that come up in all of these various privacy laws do have exceptions. They're not completely absolutist. And that's something to keep in mind, too.
So if anybody in our audience has any questions for our expert guests today, just type them there into the chat box and we'll get to as many of them as possible. Steve, you mentioned anonymized data. And so there's this concept of PII, personally identifiable information, right? Mm-hmm. So talk to us a little bit about that and how that fits in.
Yeah, so it's depending on the law that we're talking about, it's a different term. PII I associate with kind of the old style personal information where it's your name, it's your address, it's your social security number. The modern definition that we see in GDPR and some of the state laws is a little bit broader. It's any information that is identifiable or could be identified, and in some cases could be linked to an individual or an identifiable individual. And again, it's a lot broader than it sounds. For example, cookies, right, or some sort of a personal identifier, or a unique identifier on a mobile device. If you can identify that it's the same guy twice, that is considered personal data under these statutes. Oh. And so again, way broader than I don't know it's Joe Smith, but I know it's the same guy twice. And I can identify him and build a profile on him and things like that. Mm-hmm. That's personal information or personal data, and that would be subject to GDPR, CPRA, all these various state laws. But it does have to be reasonable. And so if you anonymize it in a way that I can't reasonably identify it's the same guy. So example, the unique identifier, if I truncate it, that there's 1,000, people who might have the last 4 digits, that's fine. And so you have to analyze, what other information do I have and can I reasonably link it up to the same guy again? And if the answer is no, you've successfully anonymized it and you're meeting the requirements under the statute.
Interesting. So I always tell my Stanford students that, running a startup is hard enough as it is. Don't don't make it harder by getting into trouble with the regulators. It's much easier to stay out of trouble than it is to, deal with investigations from the regulators and potential fines. And,
Right.
You want to be spending all of your effort, growing your company and taking care of customers, not responding to regulators. So again, I'm kind of circling back around on our original question about what can startup founders do to make sure they're clean on as many fronts as possible. And of course, most startups are working on constrained budgets, so they can't sign an engagement letter with Foley and Lardner saying, just do all the privacy stuff for me.
We could do that very efficiently. And obviously there's alternative fee arrangements and things like that. But I would make sure that they're dealing with the regulatory environment that they're going to be operating in, again, kind of earlier rather than later. Whether that involves a compliance officer, whether that involves, hiring an outside law firm, even an outside law firm, I can answer a couple of questions, or I can draft all of your policies, right? And anywhere in between. And so it really depends on, what's the appropriate thing for the company. And I've worked with startups where, it's an hour conversation and I don't hear from them until they hit unicorn status. And I've had other clients that, hey, I'm involved in, day one, they want all the policies and procedures drafted and put into place, and they'd like me to draft it. Again, I've done ones where they've drafted it and I just look at it and say, okay, yeah, that looks appropriate, or maybe we want to tweak this, or whatever it necessarily needs to be.
And you mentioned privacy policy, that's for many startups, that's kind of the first place, is they know they need to develop some sort of privacy policy, and it should be something it should be linked to from the website, right?
Yeah. So despite talking about thresholds and GDPR and CPRA and all that, there's the old California Online Privacy Act, which goes back to 2003, 2004 timeframe, which requires a privacy notice on any online site or application. And that has some specific requirements in it. So yes, at the bare minimum, having a privacy notice that complies with those obligations should be day one.
And so I just do a quick Google search, find somebody else's privacy policy, and put it on my website. Is that what I do?
No. So the days of kind of one size fits all privacy policies are gone. They've been gone a long time. Yeah. It should be tailored to what you're actually doing. Mm-hmm. Keep in mind that a privacy notice is essentially a contract between the company and the individual who's given the information. And just like anything else, any other contract, you don't want to breach it. And so if you're saying you're doing ABC in the privacy notice, particularly you're not maybe doing ABC and you actually are, that's a problem. And that can be enforced under the FTC, which is the Federal Trade Commission Act, and I can't remember what year that is, but basically they have the ability to regulate unfair and deceptive practices, and they have made various determinations over the last 15 or so years that core security practices is considered an unfair and deceptive practice. And not disclosing something that should have been disclosed in a privacy notice, or saying something in a privacy notice that's wrong, is an unfair and deceptive practice. And every state has a similar law. California, it's Business and Professions Code 17200. Other states have very similar ones. And the FTC is very active in enforcing it. I'd say, depending on the state attorney generals are pretty active in enforcing that as well. Mm-hmm. And individuals may have a right of private action under a lot of those states as well. So that's even more of a problem. You just get, a bunch of class action people who want to file a litigation.
Do either of you have any experience with kids? That I think that if you have users under 13, that kicks in some federal stuff.
I do. So that's COPPA, right. which is a federal law. Also goes back, probably 20 years or so. And that's interesting. So that's children under 13. And if you collect information about a child, or actually from a child, so it's not necessarily about a child, it's from a child under 13, And that also includes, again, kind of unique identifiers and things like that. It doesn't have to be name and everything.
Yeah.
You need verifiable parental consent.
Verifiable parental consent. Yeah. Okay.
Which the FTC has very specific ways that you can get that. Things like, a 1 penny charge to a credit card, or actually like a video conference to verify that it's the parent and not some really smart child who's actually making them sound like they're the parent. And then under California, we now have the new California Child Design Privacy Act. I think that's what it's called. It just got passed 2-3 weeks ago, which is also going to have similar requirements, but it's for children under 18. And expands that even more of, you have to consider the harm that could be imposed to the child based on the information that they're collecting, and you have to design things around that. So even that's, recently, the bar is going up, even these old things that we thought were settled a long time ago.
Yeah. Yeah. So Stephanie, does Wasabi have any customers dealing with health data such that there's HIPAA issues?
We do. Yeah. We've got, customers that kind of run the gamut and, from all different sectors of the economy that store data with us.
And can you talk at all about the HIPAA stuff?
So we have a compliance officer that kind of really
focuses on that.
Not just on HIPAA, but other sort of regulatory schemes that affect the services themselves. There's really specific security rules specifically for HIPAA, for HIPAA data, and kind of the controls and the audits that you have to be able to pass to process HIPAA data. And then there's also contract considerations, specialized BAA contracts and things like that have to be in place. It is, a bit of an undertaking to sort of go down that path of becoming a processor of specialized data like HIPAA data, or, data from the federal government, or sort of these, unique sets of data beyond just the general bucket of personal data.
So, there's so much domain expertise that is required, right? You just mentioned having, that you've got, compliance officers, that's all they focus on. And again, that circles back to my question about, how the hell do early stage founders deal with this when they can't afford to have Stephanie in-house? Do you have any thoughts on resources that they can turn to? Or is it just make sure you're doing your due diligence, make sure you spend time reading these regulations, figure out which ones apply to you?
Yeah. So, I think it is table stakes these days. There has to be due consideration given to security and privacy issues. That's unavoidable. But sort of how much you want to take on at the early stages is within your control, right? Like, how do you want to grow your business? Do you want to allow customers that have HIPAA data? That's going to be a big undertaking. Or are you going to just not go after those customers and, you put something in your contract around warranties that a customer isn't going to, put HIPAA data on your platform or send it through your services, that kind of thing. Are you going to, focus on organic growth within the US first, before you expand to Europe? I would say, some of that stuff is in your control about sort of how fast and wild you want to grow your business. And then begin, you need some sort of resource, either inside counsel or, outside counsel like Foley, or
right.
There's different resources you can use, sort of depending on what level of program you're going to undertake. And, we kind of joked about copying a privacy policy that's out there. You definitely don't want to do that. But I do think it is useful to sort of look at what your industry peers are doing. If you're a 1-year-old startup and you've got 35 employees, you don't need to have the privacy program that Apple has, right? Like, nobody expects that. But you do need to sort of keep your eye on what your industry peers are doing. And you certainly don't want to be the only one sort of not doing the basic things that you need to do. So, look around. Do they have just a privacy notice, or do they have a DPA out there? Do they have information sort of about their general privacy practices, and sort of see like what are industry best practices that can help guide a little bit in terms of the scope of the program that you want to develop internally?
Right. Yeah, I think that's a great tip. Take a look at every startup has, peers out there in the marketplace that do approximately what they do. So, look at two or three of them, see what their privacy policy is, see what things they have in place. I think that's a really good tip. Really good tip.
I think knowing the market is obviously important, but as Stephanie said, knowing what industry you're going to be operating in is also really helpful, right? I mean, I'm sure there are plenty of startups that will never touch HIPAA data, right? It's just not part of what they do, right? They're not cloud storage providers like Wasabi, like they, they're doing whatever, and so they don't need a business associate agreement, right? They don't have to deal with HIPAA stuff, but they may be subject to some other privacy laws like CPRA or GDPR or something.
Right. I'd also say, check with the regulators that, for example, the California state website has pretty good information on it about California privacy law. So, check with the regulators. It's free. They'll give you free advice. Might as well look at what they have available.
Yeah, to the extent that it's understandable.
Yes, I understand.
I would say some of the, I'm looking at the regulations for CPRA, and it's not easily read. I'll say. A, it's not a page turner, and B,
right.
You might have been doing quantum mechanics for some of the language that they've got in there.
Right. But some of them do a pretty decent job of having material that'll help you get up to speed on generally what it's about.
Yeah, the FTC does too. At the federal level, all things like HIPAA and everything is regulated by separate entities. A lot of kind of the general, consumer, I would say, privacy, security, type regulations are regulated by the FTC. And so to use your example earlier, things like COPPA, the Children's Online Privacy stuff is regulated by the FTC. And they've got some pretty decent pages and FAQs on this is how it applies, this is what you have to do, no, you can't do this, yes, you can do that. They're very helpful in some of those things.
So last question for you guys is, what's on the horizon? Is there any kind of regulation that's in the pipeline that is expected?
It's a constantly changing area, as I think we've mentioned earlier. Breach notification laws started in California in 2004, and it took roughly 14 years for it to make it across every jurisdiction in the U.S., with Alabama being the last one. CCPA was enacted in 2018, went into effect 2020. We've now seen CCPA be replaced by CPRA as part of a ballot initiative last year. And we've seen 4 other states now pass laws that are associated with it. And at one point, I think I had counted something like 23 states had proposed laws similar to it, and some of them have been reproposed. And Michigan just proposed a new one last week. And so I would expect that we will see more states have proposals for and probably pass privacy laws that are similar yet different than California. I am not particularly hopeful about the federal privacy law.
Yeah, that's great. That's good. My next question was: Are the feds ever going to unify this?
I doubt it. I mean, they haven't unified the breach notification stuff, and if you get a breach, it's kind of a pain if it's nationwide. I think the preemption thing, which you've probably heard, is going to continue to be a challenge. And as long as there's going to be a challenge to preemption, you're still going to have every state law that's going to apply and maybe raise the bar from the floor that the federal law passes. I'm actually kind of surprised that the federal law has made it as far as it has, to be honest. There are 6 or 7 different committees in the House that all think that they own privacy, and they all compete with each other. So I'm surprised they even got as far as coming to some sort of an agreement to what they got. But I think it's going to be a long time before we see a federal GDPR. It would be great if they did. for no other reason, if they make it at least close to GDPR, it would make things like transferring information from Europe so much easier than it is now, assuming that it got an adequacy decision. But I think we're years off. So I would look for more states. I would look for more states, not only doing the general one that we've seen: California, Colorado, Virginia, Connecticut, Utah, but probably a few more of these sectoral ones. I think social media has got crosshairs, and they're probably going to have. That may actually have a federal law at one level or another. But I think we're going to see more states do that. And I think the children's one that was just enacted in California is also going to be the tip of the iceberg, mostly generated from things like Instagram and TikTok, and again, kind of more of the social media company that they're targeting.
Well, speaking of which, yesterday we got the news that Section 230 is going to go to the Supreme Court. Which isn't privacy specifically, but it certainly is part of this whole general thing you mentioned, Steve, about social media companies being in the crosshairs of the regulators right now.
And they're going to still be an exception as an internet service provider instead of an internet content provider.
Right.
230 is outdated.
Well, we should have a separate panel on that one, because that's a whole different topic, but it's a big juicy topic.
Yes. Yeah.
Okay. Last question. Stephanie, what keeps you up at night?
Oh, boy. I'll answer this a little cheesy, which is, not too much, because I have the support of a really, really great business team that cares about this stuff. And so to the extent that I sort of, see scary stuff out there, I've got the support of the business and they're behind me to help address it. So,
there you go. Nice.
it's just sort of the daily task of keeping up with everything is difficult, but once I've identified it, I've got a great team, and we're working towards getting all this stuff right. So
that's a nice, warm, fuzzy answer. I like that. So, Steve, what do you recommend your clients think about in the middle of the night?
That's a great question. I think, again, we've kind of touched on it a little bit. And what is the nature of their business, and how do these things apply to them? And sometimes it gets down to, again, a little bit of a reasonableness standard. I think some of the regulations that we've seen recently, they're clearly written by people who don't have a tech background and maybe don't understand the industry. Unfortunately, sometimes it's like, look, we've got to make best efforts to comply here, but we're not going to be 100% compliant, because nobody is ever going to be 100% compliant with these somewhat ridiculous requirements sometimes.
Okay. All right. Well, Stephanie and Steve, thank you so much for doing this. You can find me and Stephanie and Steve. You can find all of us on LinkedIn. So please reach out to us if we can help in any way. And thanks so much for joining. Stephanie and Steve, again, thanks for your time. Really appreciate it.
Thanks for having us. Bye.
This has been the Fourthly Podcast. If you'd like what you've heard, I'd really appreciate it if you could spare a moment to share and review this show. Your support truly makes a difference. You can find out more at fourthly.com. Until next time, I'm Bret Waters. Thanks for listening.